Hi, everybody. My name's Isaiah Adair. I'm an attorney at Helen Tarakeech Law, and I wanted to make this video to talk to you today about the question that I get the most in my consultations. And that's, if I have an immigration violation, are these options we're talking about even possible? So my consultations are usually for U visas and T visas, mostly T visas. And the answer is yes. Usually, these options are still available if you have immigration violations. But some different questions need to be asked first, such as what are the violations, when did they take place, and so on. So how is this possible? How is it possible to waive immigration violations, to still have these visas as an option? So there's this form called the Form I-192. It's called the Advanced Permission to Enter as a Non-Immigrant form. It's not available for everything, but it is with the applications I work with, again, the U and T visa applications. And what this essentially does is it pretty much just asks us to disclose the information, to tell them the information honestly, and then we can just ask them to forgive those violations. It doesn't work for every violation, but there are quite a few that it works for, that we try to use to help our clients. There's no guarantee that it'll work, just like with any other application or any other form. It may be approved, but it may not. So we would file this in combination with the T visa or U visa forms, and usually try to at the same time. And if the primary application is approved, that's when they would move on to make a decision on to the other form. But we would try to file them around the same time or at the same time. So for most people, there are some standard immigration violations that we look at. Um, if you're here without documentation, if you entered the US without papers, there is one ground that we request for most of our clients. That is to waive your presence in the US without admission or parole, which is just your presence in the US without immigration allowing you really to come in. So that's one. And another one that we generally ask for is we call it like the documentation requirements ground. We use it for a lot of our clients, but it can be used in different situations as in if you do not have a valid passport or if you currently don't have a visa, showing your presence here is lawful, even if you did when you first entered the US, to kind of differentiate or show the difference in that one and the one I mentioned before. This waiver is what they call discretionary. So it's not something, again, that they have to approve if they approve your other application. Discretionary just means it's up to them. So they'll look at your history, they'll look at all of your violations together, maybe your criminal history as well, and they'll just weigh the options. So another question may be, what do I do if maybe I entered the US with my child, like carrying my child, or with my child behind me? Or if I was already in the US and I paid for my spouse or my kids or someone else to enter the US without papers. Then we might think, okay, maybe the smuggling ground of inadmissibility may apply. So maybe we need to talk about waiving that. Another question may be, well, what if I have came to the US and then I left, or maybe were removed back to the country that I was born or the country I was in previously, and maybe I come back in. What can I do there? Because I've entered twice without papers, maybe have been removed in the process, maybe have been detained or arrested or caught by immigration. What do I do? So those are things that we could also talk about. Okay, can we do a waiver for that? And generally, that's not what we consider like a case killer for U or T visas.